Good evening. This is our test question review for the Institute of Real Estate Education for tonight. And we're working on Utah law. So for all of you out there on the internet that have found us and probably YouTube and are enjoying our classes on national law, well, you don't have to watch this one unless you want to take the Utah exam, because tonight we're going to be working on Utah law concepts. So I'm just giving you a warning. Unless you want to take the Utah law test, you know, you probably want to watch one of the other videos that does the national topics. Okay, but we're glad you're here, and Tiffany, I see you're on, and this is great because if you're looking for a Utah law license or the Utah real estate license, this is the place to be. And we've had so many students over the last few months that have benefited from our YouTube channel, and we're happy you have. You know, it's and a lot of them have just found us by Googling, national real estate exam or whatever you're Googling. And you're welcome to it. We're welcome to the content. And if you want to take advantage of a lot of the things that our school also offers, you could come to our website and you might be surprised what might be available to you. But tonight we've got about 16 different questions in Utah law. So let's get started right from the beginning, which is where we begin. Okay, it's a Utah law. Education, Research, and Recovery Fund can be used to satisfy judgments against. Well, is it A, active agents only, inactive agents, active and inactive agents, or the problematic clients? Well, we're not going to have a law in Utah that even though you're a problematic client, that penalizes you for that, because we don't license you, we license agents. And so it's the agent. Throw that one out. So it's either active or inactive or both. What do you think, guys? It's got to be both, okay? If you've messed up, just inactivating your license is not going to get you out of trouble. So, it is the answer to this one that if you get in trouble and you go to court and a judge says you were wrong and you should pay a fine and you can't pay the fine, then that's what part of what their recovery fund is for. And of course, you're gonna lose your license if the recovery fund pays a fine for you, and then you're never going to get another one unless you pay it back, plus some other penance you're going to have to do. But the correct answer to this one is active and inactive agents could be covered by the state for your wrongs through the Utah Real Estate Education, Research, and Recovery Fund. But it's got to go through the court of a court of law. It's usually going to be a county court, and the judge is going to rule that you were wrong and you should pay this fine. But you haven't, or you can't, and so what they have to do is their lawyer that pushed that through county court is then going to file a petition with the Utah with the real estate division, and he's going to try to tap the Utah Real Estate Education Recovery Research and Recovery Fund. And if that happens, they're going to revoke your license, and you're not going to get it back unless you pay the recovery fund back and a few other penance that that they're going to make you do. So let's go to number 2. Okay, to receive payment from the Utah Real Estate Recovery Fund, the injured party must file a notice claim. Hang on to that one. Win a lawsuit against the agent. Okay, hang on to that one. File a petition for payment with the Board of Realtors. Forget about it. Board of Realtors is our private club. That's what we pay our dues to and whatnot. And we have activities, we have meetings, we have education, we have parties. And we have a beautiful building here in Salt Lake City, Utah. But it has nothing to do with a recovery fund. Recovery fund is on the legislative side. Recovery fund is on the state government side. Okay, so, but remember, I already gave you a hint on this one and with the previous question. So the answer to number 2 is D, obtain a court order ordering the fund to pay. But first, you got to go through judgment process. The agent must lose in court. Some judge says that you did wrong and you need to pay this, but you don't pay it for one reason or another. And if the state so the lawyer then files a petition with the Division of Real Estate, and if they pay out of the recovery fund, it's going to get more complicated for you. They're going to revoke your license, and it's going to be a mess getting it back. And you're going to have to repay the fund with some interest and some other problems. And they might do a lot of things to you. You don't want to go there. I mean, if some judge says you were wrong and you need to pay a fine or a judgment, then you need to pay it. Number three, but if they get with the recovery fund, that's what it's partially there for. Number three, the damages payable as a result from lawsuits against the real estate agent, A, can be avoided by the agent filing bankruptcy. So the judge says you were wrong and you owe 5, 10, 20,000, whatever. Okay. You file bankruptcy. Well, if you file bankruptcy, that's going to kind of set aside some of the debts you owe, even if they were court ordered. Okay. But B, cannot be avoided by the agent filing bankruptcy. C, may be avoided by bankruptcy, but the recovery fund must still be repaid. That's if you want a license again. Or D, are increased by payments from the recovery fund. I don't know why it would be increased. I mean, if the judge ordered you needed to pay $5,000, $10,000, whatever it is, they're not going to increase it. But anyway, so the correct answer to this one, number three, is A, can be avoided by the agent filing bankruptcy. If you file for bankruptcy protection, it's going to get you out of a lot of debts, not just particularly this debt. It's going to get you out of any debts. Now, if it's a secured debt, like for your automobile or whatever it might be, you want to keep that item. You're going to have to reinstate that debt. I mean, or they're going to get nasty and come hook it, take it away. But if you file bankruptcy, it will protect you, but it won't protect your real estate license. If a payment's made out of the recovery fund, they're going to revoke your license, period. Okay. And you're not going to get another one. And you probably won't get another one in another state either if you decide to move and try it again in another state, because they all keep in touch with each other. Number four.
Hey, hope you're enjoying the video. Be sure to like and subscribe so you don't miss any more of them. And if you want even more review material, we have in the Prep My Exam link in the comments, we've got a plethora of practice exams. We have audiobooks. We have an exam simulator. We have everything that our students use to pass the exam on their first try. Okay? And if you want to get licensed in Utah, check out realestateonlinelearning.com and we'll hook you up.
What is the maximum that the Real Estate Recovery Fund will pay out to a single claimant? And as 15, 30, 50, or 60 grand. Well, guys, it's $15,000. If the judge ruled that, you needed to pay $20,000 recovery, they're going to cover the first 15. That caps out at that one. But it's still going to get real nasty on you. Okay, so answer number four is A, $15,000. Boy, things can go sideways. You got into real trouble here. Hopefully, all this could have been avoided by being actively supervised by a broker that knew what they were talking about. We see payments made out of the recovery fund occasionally, but it's not an everyday occurrence by any means, because of all of the hassle. I mean, you're going to lose your license. And if this is what you're doing for a living. Now, if you're not doing this for a living, didn't work out for you and whatever, maybe you don't care, but they're going to push you. They're going to come after you. They're going to try to get the money back in the recovery fund. Number five, water rights. Water rights in Utah. Water rights in Utah are not always included with the real estate in Utah because we follow the doctrine of prior appropriation, habeas corpus, which has nothing to do with this, amortization, which has everything to do with loans and nothing to do with water rights, the effective age, which is an appraisal term. Okay, so it is a prior appropriation. We are a prior appropriation state. We are a desert state. In some states, if you own the dirt, you own the water. But those are not desert states. When you get out here in the desert, there's a separation between the water and the real estate. And in the states back east where it rains all the time, you got plenty of water. You own the dirt, you own the water. But in the desert states, prior appropriation. Prior appropriation means that someone got there before you and probably has the water already dedicated to them, assigned to them through the state engineer's office. but it's done on an application. It's done on what they consider the most important category, and then the next, the next, the next. Now, Utah, the most important category is agricultural. And then after that, it's industrial. And then last, it's potable water, water that you can drink and whatnot. But potable water really doesn't take that much. But nevertheless, there's priorities. And so if you are filing for the water rights because you have a farm, you're favored. If you're filing for water rights because you need it for manufacturing, you're favored. But but you got to drink. So it's in there somewhere, but it's kind of down on the list. But then it doesn't take that much for that anyway. And most people aren't drilling wells and getting their water. They're hooked into some sort of municipal water system. And in order to run that water system, of course, the water department or the city, the county, whatever it might be, subdivision, they have to own the water rights. You know, okay. So number 6, the water rights, water law is a real fascinating topic. And if you're going to be doing any larger acreages, if you're going to be doing any industrial manufacturing involves water, if you're going to be doing um, a lot of that type of stuff, farms, ranches, you need to take a water rights class. And, there's some really good ones out. We have one at the school we're looking at right now that's really exciting. I mean, this is, of course, all this is administered by the state engineer's office, but it is, it's a fascinating topic. There's only a handful of real estate agents that really specialize in water rights. I mean, you can count them on less than 2 hands. Okay, and they're getting older, and a lot of them are retiring, and it might be a niche that you want to look into, and it would be really cool. All right, well, this wants to know that who handles all the applications and the distribution and the record keeping and all this. It's the Utah State Engineer's Office. Okay, which is answer A. It's not the tax commission. Give me a break. It's not the Department of Land Management. I don't even know if that's a real thing. And it's certainly not the Division of Real Estate. They don't understand it. They regulate it, but they don't understand it. Not to anyway. I mean, they do understand it, but not to the degree that state engineer's office. They have specialists. There is a water rights department in the state engineer's office, and man, these guys really know what they're talking about. If you take a listing that involves water rights, I would run right up to the state engineer's office and have it all explained to you, because it's going to be a big deal, particularly if it's agricultural or husbandry, animal based type of an operation. Those water rights are critical. In fact, sometimes the water rights are worth more than the dirt, and if you can believe that. And of course, like I was intimating earlier, you can actually sell water rights. You can list water rights, because it's, you have a real estate license. Okay. Yeah, here's Dan. Well, you saw that. All right, let's go to 7 or 6. No, 7. Cool. Well, if we're gonna have the water rights department, and the state engineer's office is going to figure out how much water there is, and they're going to have a resource and a procedure on applying for it, and they give it out based on, like I was talking, that hierarchy I was talking about earlier. um, then there's got to be a mechanism for determining how much water is there. And now in heavy water years there might be more or less, but water rights, your right to use those endure. You don't have to keep applying for them every 6 months or every year or whatever. If you're given a water right, it's a real property right, and it's actually transferred with deed. But this is it's not the county's it's surveyor. It's not the state resource manager, and it's certainly not the Public Service Commission. Come on, it's the state engineer's office. I mean, these are smart people, and this is big money. I was talking to a lady who's written a phenomenal water rights class that, like Dan said, he's reviewing several different classes right now. But she was told me about a piece of property where the dirt was worth this much, but the water rights were worth $2 million. And so uh, don't underprice a property just because you're not that familiar with water rights. If you've got water rights attached to it, now there is a difference between a water right and a water share. Water shares are shares of stock in a usually an irrigation type cooperative or resource company type thing that own the water rights. Okay, so they take the water rights, it goes into this irrigation company or something that is servicing an area, and that organization owns the water rights, but you're given shares of stock or shares of you get a stake in that company, and um, so there's a difference. Water shares, a lot of time you can have one or two shares of water, but you don't own the water right. You own shares of essentially stock or an interest that is divisible in the organization that owns the water right, and it's fascinating. I mean, it's something you really ought to learn about if you're doing any type of property that has a water rights attached to it. You never know. Those listings come up, and the people trust you, they like you, they know you, and they list with you, and you have a responsibility to them to give them the best service possible, which would include understanding the water rights. So take a class. We're going to have some really good ones real shortly. We have some now, but we're going to have some even better ones. Number 8, please. Now, water is appropriated. Okay. And well, of course, the answer in number 7 was state engineer. I mean, anything to do with water rights, it's state engineers. Okay. Once water is appropriated, the right to use it could be lost if the right is not used for a period of how many years. So I talked to a lot of people that own kind of like undeveloped land. I mean, they were thinking about turning it into pasture, but they never got around to it. But if they got the water rights, but the irrigation circles or maybe other types of distribution are available to them, but they never really got around to it, maybe, or they decided not to put that into farm type land. Whatever reason, they haven't been using the water rights. Well, at least once every period of time, they better be using them, or they could lose them. And what is that period of time? Is it 5, 3, 7, or 20? Well, 20 is kind of long. Probably throw that one out. I mean, look at your other 3 answers: 5, 3, 7. I mean, 3 is kind of short. And well, is this a Cinderella approach? Well, anyway, but so we're looking at number 7, guys. I mean, answer 7, C, because if you don't use them, you're going to lose them. And how many years? 7 years. This is a very common question. Very common question. So kind of stare at that for a moment. 7, 7, 7. Don't. I mean, if think of. Well, don't think of that. Anyway, just 7. All right. Whatever works for you. My mnemonic devices sometimes are kind of weird. Let's look at number 9. But, hey, if it helps you remember, that'd be cool. But you probably have your own. A mechanics lien can only be filed against a property where. Okay, mechanics lien. Okay, can only be filed in a property where A, actual labor, materials, or professional design services were applied or supplied. B, estimates were given on a potential labor project. Just an estimate. C, a real estate purchase contract has been signed. Okay, now a real estate purchase contract, that's a buyer and a seller getting together to decide to, one's deciding to sell, one's deciding to buy. What's that have to do with a mechanics lien? Well, a mechanics lien can certainly mess up your deal, especially if there are repairs that are required for the property, like a new roof or whatever. But hang on to this, okay? Or C, a real estate purchase contract has been signed, or D, the mechanic resides. Okay, no, D is not right. So, I mean, what we've got here, folks, not a failure to communicate, is answer A. Actual labor, materials, or professional design services were supplied. Okay, it wasn't estimates. It wasn't purchase because of a purchase contract, and it's certainly not a place where the mechanic resides. I don't know. I don't know. Hey, I guess some people might sucker for that. But anyway, the right correct answer is A. Actual labor, materials, or design services were. I mean, something happened. Something was delivered to which improved the property, and then the people that sold them the lumber or the carpet or whatever were never paid, so they filed a mechanics lien saying, "Look, we improved this property and we deserve to be paid, and we haven't been. So we're filing a mechanics lien and we're going to pursue other collection methods to get our money." And or we delivered materials and it was built into the property. Or we did design services, and we want to get paid, and they're not getting paid, so they file a mechanics lien. The ultimate thing that could happen to a property owner on a mechanics lien is that property could be foreclosed on. So it is it's pretty nasty collection process. So I mean, if you contract for work on your property or materials or design work on your property, pay your dang bill. Otherwise, it's going to get kind of nasty. Number 10, if payment is made after the mechanics lien is filed, the person that's filing a lien must provide a what? All right. So there was a mechanics lien on this property, and it's not for everything. I mean, what if the appraiser did an appraisal and it wasn't paid? Well, it had nothing to do with providing materials or improving it or doing design work on the property. So you can't file a mechanics lien for that type of service or an inspection report. You can't file a mechanics lien for those types of things. But if it was in those other categories, you certainly could. But so there's one there, and maybe out of the closing it's paid off, or maybe even before the closing it's paid off. Hopefully, before you even list it, it's paid off. So, what do you think you'd have to do if you had paid that bill to prove you'd paid the bill? You need to get a what? Notice of completion. You need to get a agency agreement, a good faith estimate. No, you need that A lien release. You need a lien release. Okay, and we have real specific rules on mechanics liens in Utah that were revised not too long ago, and it's you need to be familiar with them because it is a test subject that they're very fond of. But obviously, if um, you paid something off, you want a lien release, and particularly for a mechanics lien, because you're going to have to file that. So that the title company is satisfied that it was actually paid off. Otherwise, they're going to try to, they'll have to take money out of the proceeds in order to pay it, or they may even refuse to close the transaction. I don't know. Number 11. Number 11 says if a contractor files a mechanics lien for an amount greater than the debt owed, they're cheating. They were only owed this much money. They can't pump up the volume just because he wasn't paid. And, well, I want something for my time and effort, in order to collect this. You can't do that. It's, it does break a law, but it's not a felony. Okay. Now, would there be moral turpitude? Well, I guess you lied, but it's not a felony, and it's not a statutory fraud. It is a misdemeanor. See. And who cares if you violate the rules and regulation of the real estate division? Well, you will if you have a license, because that's who they can go against. If you don't have a license, they really can't even go against you. It's been a real problem in our state, where they wanted to go after someone, but they didn't have a license, so they couldn't go after them. So they've tried to get that changed in the legislature for a few years, but we'll see how that pans out. So it's a misdemeanor, which is breaking the law, but it doesn't carry the same sorts of penalties that a felony would. It's a misdemeanor, but it is a misdemeanor, and it is against the law. If you have a contractor's license, it could definitely affect any type of license, a real estate license, contractor's license. Heck, might even affect your beautician license if if you had both. Because revocation of your real estate license might affect your beautician license. I mean, state licensing bureaus are kind of work together a little bit. If you're a misfit, they figure you're going to be a misfit in all aspects of your life, I guess. Number 12. Hey, but if you still give a good haircut, maybe you can just do the neighbors. I don't know. Number 12. Which of the following notices is not one of the steps under the state construction registry? Now, the state construction registry has to do with mechanics liens, and uh, what do you think it is? Do you think it's notice of intent, notice of commencement, preliminary notice, or do you think it's notice of completion? Well, man, I tell you, it's notice of intent. See, I fooled you. Previous question, I kind of skipped that one over because it was the right answer. But in this one, which is number 12, it is notice of intent. And that's because it's not one of the steps. See, notice of completion, notice of commencement, and preliminary notice are all steps in the mechanics lien process. And I mentioned a few minutes ago that you should be familiar with that, and this is why. Because notice of intent sounds really good, but it's just not right. It's not part of the process. Let's look at number 13, please. Now, an estate or an interest. If you have an estate, it means like you have an interest. An estate or interest in real property must be transferred by what? Handshake and verbal agreement? Yeah, right. A contract in writing or operation of law. Ooh, that sounds warm and fuzzy. Express mail? Boy, these devious exam writers. That sounds real official. An agent of the owner. Agent of the owner. Well, hi, I'm an agent for the owner, and I'm filing a notice with you. Okay, all right, whatever. Guess what, guys? Number 13, it is contract in writing or operation of law. In other words, a judge can do a whole lot of things, but a contract in writing would create an estate or interest. But then, I mean, a judge could do some things too, and they could do some preliminary things before they make the ruling, and they certainly can do some things as they make the ruling in a court case. So an estate or interest in real estate must be transferred by contract in writing. Would that be a deed, or perhaps lead to a deed? Operation of law, could the judge put a lien on a property, or even do several other things, even transfer a property, or force someone to transfer a property? Yeah. So anyway, answer is B. That's a good one. It could establish an estate or interest in real estate. Let's look at number 14, please. All right, number 14 talks about different types of documents, and occasionally you're going to need to prove that that signature was done voluntarily and also was the real person, and so documents like these need to be notarized. In becoming a notary in the state of Utah, there's a fee, and you have to, demonstrate that you know a little bit about what you're talking about, and you can become a notary, and then you witness signatures, and you put your seal on it, and you have to get a bond. But can it be transmitted by registered mail? Can it be transmitted electronically? Can it only be transmitted by messenger? Yeah. Okay. Yeah. Okay. Yeah. That really sounds, in our electronic age. Anyway, D can be only be recorded. A copy of the recorded document then must be mailed. Okay. Think it through here. Okay. If COVID taught us anything, it could be that we can do a lot of electronic things. Okay, and so look at B, because that is the right answer. Okay, but they got to be what? Notarized. So what a notary is very important in deeds. It's very important in loan documents. It used to be that we had to notarize titles for automobiles and motorcycles and stuff, trailers, that kind of thing. But kind of backed away from that. I'm sure the people that do notaries for business were not too happy about that. Number 14. We just did 14. 15. Two more to go. All right. Agent H represents the seller. They receive an offer on the property and the seller signs the real estate purchase contract, which we call the Rep C, to accept the offer. Agent H sends the contract to the buyer's agent by email. So what is true? All right, well, okay, we got H. He's an agent. He represents the seller. They get an offer. He takes it to the seller. The seller says, "Oh yeah, this is a fair deal. Yeah, I'll take that." And they sign it. And then he sends the contract to the buyer's agents by email. Okay, so what's happening here? This is number 15. Okay, and A, the contract is not legally binding because it was transmitted electronically. Okay. B, the contract is not legally binding because the seller did not deliver the contract themselves. C, the contract is legally binding because the language in the Rep C allows email transmission. Now, if you're familiar with the Rep C, you read the section on this. And of course, that is the correct answer. But D says the contract is not legally binding because the agent at H did not sign it. Well, we're not a party to a purchase agreements. Now, we might initial that we received a copy of it. We might, there's also a section where we're identified, but we're not. A contract for purchase is between the seller and the buyer. Now, you may handle it. You may actually write it. I mean, you may show them where to initial and where to sign, but you're not a party to the transaction. That is between the buyer and the seller. Okay. So correct answer is C. Contract is legally binding because the language of the Rep C said that, handwritten signatures, whatever, are okay, but also electronic signatures are okay. There was agreement between the parties in the agreement itself where the parties agreed that electronic signing was fine. And that's why it became binding. Okay? Because they said that was okay. That was part of the agreement. Number 16. Number 16 talks about the statute of frauds. And the statute of frauds is one of those contracts, one of those types of agreements that's pretty much the same in most states. I mean, we do a lot of cross-state borders commerce in different things. And of course, your driver's license is good in all 50 states. If you had a Pennsylvania driver's license, you can drive here just fine. But in this one, number 16, the correct answer is A, if the contract is enforceable. So the statute of frauds says that it creates a binding contract if it's signed. And it's not who gets the commissions. That could be the purpose of the contract, or that could be a provision of the contract. But that's not what statute of fraud talks about. Statute of fraud talks about what makes something binding and enforceable or not enforceable. See whether an offer can be accepted. Okay, well, not really. I mean, that's not what the statute of frauds is all about. Statute of frauds makes it enforceable. D, where the trust money can be deposited. Well, that might be a provision in the contract, but that's not what the statute of frauds. Statute of frauds really regulates or defines enforceability, and it could be all types of contracts, even one where, trust money or earnest money is not even provided. Well, I hope you found this helpful. I know that many individuals, even a number of which are not uh, testing in Utah, have found Dan's site, and they I get comments from them all the time, and then they say, "Wow, we really enjoy the national portion reviews." And of course, this was, and we had some national mixed in, but this is primarily a Utah review, and we appreciate you being here. As always, if there's anything that we can do to help you, feel free to get a hold of us. Dan's available, and so am I. My personal email is 801-556-8000. That's 556-8000. And with the Utah prefix 801 in the beginning. And we appreciate you being here tonight. I hope it was fun for you. We enjoy doing these classes, and we enjoy helping you get your real estate license. So uh, call us if we can help. Take care.
Thanks for watching. If you want to show some appreciation to our instructors, be sure to like and subscribe so that they see how much you enjoyed it. And if you want any additional review material, check the links below for our full suite of practice materials for the real estate license exam. Thank you.